What an eventful day! Hello again, my fam. It is Perez, the queen of all media, the original influencer, and still your number one source for everything It Ends With Us saga. A few hours ago, I shared with you all a video with these newly unsealed text messages that I think do not make Colleen Hoover, the author of It Ends With Us, or Sony, the film's distributor, look good. Both come out with stink on them. And I also told you all that tomorrow is the deadline for motion for summary judgment. I said two things. Well, I said many things, but I pontificated that one, the Wayfarer defendants should release their motions for summary judgment today and get ahead of Blaked and Afraid on the press side of things, because her publicist and her crisis PR manager are going to work hard to seed stories and their narrative. And the other point of pontification was reminding us all that Baldoni's attorney, as recently as this weekend, Brian Friedman, who's also my lawyer but did not represent me with regards to subpoena gate, said that Justin deserved a trial by jury. So does that mean they're not going to file for a motion for summary judgment? Which means at this point, the judge can determine on his own no need for a jury trial. And I reminded us that Baldoni and Wayfarer already filed a motion for judgment on the pleadings, which is very similar to a motion for summary judgment, except the motion for summary judgment takes into consideration all of the evidence and everything that's happened thus far in the trial. A motion for judgment on the pleadings typically happens before that and is just based on what is being argued. No evidence has to be considered. But this wackadoodle judge is going to be considering both arguments simultaneously. Okay. Well, guess what? Surprise! They must have been listening to me, because shortly after my video from earlier today, Baldoni and the Wayfarer parties have just dropped their first motion for summary judgment. Let's get into it. Unfortunately, this is just Jen Abel's. Jen Abel is Baldoni's publicist, and this motion for summary judgment is not in the lively Baldoni Wayfarer case. It's in the related Abel and Jones Works litigation. Stephanie Jones. However, what I find very interesting about this is their super solid conditional summary judgment approach. Don't worry, I'm going to make this short because I don't know if anybody's going to watch this video. I don't know if the masses care about the Jen Abel of it all. So, highlights. Not only is it conditional, but it's also for just her second cause of action for common law indemnification. Remember that Jen Abel was making, once again, the super solid argument that, hey, Stephanie Jones Works was my boss. I was your employee. You were aware of, or should have been aware of, everything. And as your employee, you need to indemnify me. You need to cover all my legal expenses. Briefly, I think I'm just going to read the preliminary statement, okay? So stay with me. Quote, Abel was employed by Jones Works to render public relations services to its clients, such as Justin Baldoni and Wayfarer Studios, collectively the Wayfarer clients. At Jones Works' direction, Abel performed public relations activities for the Wayfarer clients, including in connection with the film It Ends With Us. In late July 2024, early August 2024, public commentary circulated concerning purported on-set strife between Baldoni and the film's co-star, plaintiff Blake Lively. Abel and other Jones Works employees discussed how to garner positive publicity and to minimize negative publicity for the Wayfarer clients, as was within Abel's scope of employment with Jones Works. Here's where it gets juicy. In breach of Jones Works' contractual and fiduciary duties to the Wayfarer clients, Jones Works Chief Executive Officer Stephanie Jones inexplicably and covertly advised Lively of the Wayfarer client's public relations activities. Lively then caused her entity, Van Zandt, to commence a frivolous lawsuit in New York State Court against John Doe's, devoid of any reference to the Wayfarer clients or Abel. Jones Works participated in the hoax orchestrated by Lively by generously complying with a knowingly invalid subpoena from Van Zandt, which sought the Wayfarer clients and Abel's communications, and which any other recipient thereof would have moved to quash. Big fact. But Stephanie Jones was in cahoots. Based upon these communications between Abel and the Wayfarer parties, Lively manufactured a claim against Abel for allegedly aiding and abetting retaliation, when in truth, Abel merely engaged in standard public relations activities. Abel's actions at issue herein were all undertaken as a Jones Works employee within the scope of her employment and were foreseeable by and known to Jones Works. Therefore, under well-established New York law, Abel is entitled to common law indemnification from Jones Works, regardless of whether Jones realized at the time Jones betrayed her then clients, the Wayfarer clients, that her unwavering alliance with Lively resulted in Jones Works' own potential liability. This is annoying. There's some redactions from the depositions. Once again, I told you. I said in my video earlier today that I don't think we're going to get some bombshell pieces of new evidence here, but we would likely learn things from the depositions. And I was half correct, because the parts from the depositions have been redacted. Redacted! Abel's filing just a little bit ago says, at her deposition, Jones, in her capacity as Jones Works CEO, testified that, redacted. Specifically, Jones also testified that, redacted. In the legal standards section, this is just a great reminder for everybody. If you're a lay person, I've done my studying, I know what this means now, but summary judgment is appropriate where the movant, in this case, Jen Abel, shows that there is no genuine dispute as to any material fact and the movant is entitled to judgment as a matter of law. Judgment now. No need for a jury. Under argument, Abel is entitled to conditional summary judgment. Jones Works cannot escape its obligation to indemnify its employee for the work she performed during the course of her employment. Period. Super sensible. Makes too much sense, right? That's why I'm worried. They say these circumstances warrant the issuance of conditional summary judgment in favor of Abel, even though the court has not issued a judgment in the underlying action. It is well established that an indemnified party can obtain conditional summary judgment on an indemnification claim as to liability even before a judgment on or settlement of the underlying claim. As discussed above, Lively's claims rest entirely on Abel's actions undertaken during the course of her employment for Jones Works, thereby entitling Abel to common law indemnification from her employer, Jones Works. Too much sense. Sense and sensibility. Rather than holding Abel's claims in limbo, the court should grant Abel conditional summary judgment on her second cause of action for common law indemnification. They also say that New York common law requires Jones Works to indemnify Abel. A little bit more redaction here from Stephanie Jones's testimony at deposition. And they wrap things up. For these reasons, the court should grant Jennifer Abel conditional summary judgment against Jones Works on the second cause of action in her amended third-party complaint. They kept this real tight. It was short, to the point, no flowery language, no biting attacks. It was just, this is the law, this is why this needs to happen, and it makes too much sense. I don't know what's gonna happen. Fingers crossed. And you can uncross your fingers now and type cameo.com/myname. Get a personalized video from me there right now for the holidays. It's the perfect present. I love making videos for you all. Cameo.com/P to the E to the R to the E to the Z to the H to the I to the L to the T to the O to the N. Also, go get some of my merch. I've got Grab Your Friends, Wear Your Florals. I've got Team Truth. I've got I Organically Dislike You, and so much more. Check out all of my official merch, from t-shirts and hoodies to mugs, yoga mats, pickleball paddles, and more. Buypopstuff.com, buypopstuff.com. If you like my podcast, you will love our Patreon. You get an exclusive episode a week. Sign up right now at patreon.com/myname. And you can read my website for free. Yes, my website is still around and still, thank God, helping me feed my kids. Read my website every day throughout the day. If you're still watching, you know the drill. You are the 1%. You are a superstar. You're a superstar. Thank you. Watching until the end is the most meaningful thing you can do to support your favorite creators. Hit that like button, share this video, and can you guess what word I'm going to say? In the comments section, say sense. Or you can say sense, but I mean sense, like sensibility. Say sense, S-E-N-S-E. Say sense in the comments section. Thoughts on the Jen Abel motion for summary judgment? Conditional? Thoughts on everything? Let's discuss it all in the comments. Sense.